torts professional responsibility question from the July 2001 California bar examination is not a difficult question intellectually. What makes this question hard is that it is a racehorse. There's a ton of issues presented. All of them are quite straightforward, and your job is to organize a complete answer and find a home for the facts in time. Some of my answers to straight PR questions are among the least fragmented answers in the whole Master Essay Method series. But this question provokes an answer for me that is one of the most fragmented answers. Take a look at the call of the question. It reads, what is the likelihood that Wilma can succeed on each of the claims she has asserted in her civil suit against Anne? Discuss. This is a simple civil remedies call of the question, and we don't need to read the fact pattern to set up our basic approach to this part of the problem. It will be Wilma versus Anne. The first section will be an analysis of each of Wilma's theories of liability, broken down into elements, if appropriate, and then we will consider Anne's defenses to those theories, and we will consider Wilma's remedies, and we'll consider Anne's defenses to remedies. And we'll reach a conclusion. Intellectually, this is very simple to approach, the first call of the question. Now, the second call, a very standard PR call of the question, did Anne's conduct violate any rules of professional ethics? Discuss. Well, typically, we'll either organize around the rules or around the duties, or we'll just follow the facts. And as it turns out, this is an example where I do nothing more than chronologically go through the facts meticulously and analyze every single thing we learn about what Anne does, and I judge it to be either satisfactory or not. Now, let's get into the facts. This is a comparatively long fact pattern for all of the detailed questions presented, and I think that works to our advantage. Again, what makes this problem hard is that it's a racehorse question, not that any of the questions presented are hard to spot or difficult to understand. Let's have a look at the facts together. In paragraph 1, we meet Anne. She's a family lawyer. She is representing Harry, the husband, in a dissolution proceeding. In paragraph 2, Anne advises Harry that he would more likely win custody if he could show that his wife had engaged in improper behavior. A couple of days later, Harry shows up with his wrist bandaged, and he alleges that his wife assaulted him. And as a result, Anne suggests that Harry sue Wilma, and she comments that filing the suit will improve their bargaining position in custody. Probably it's true. And we're also told that Anne did nothing to investigate the truth of Harry's story. Well, let's stop right there. We are told that no investigation is done, but is any investigation called for? I don't see this as being a conspiracy where Anne suggests to Harry, it'd be a lot easier if we had a case even if you fabricate it. In paragraph 3, we move on to see that Harry wins custody based on this story. Anne refers to the tort action that she filed. Wilma denies it, the facts. The judge believes Harry, and he wins. Okay, now, at this point, has Anne done anything wrong? Answer, I don't see it. But in paragraph 4, everything comes unraveled for Anne. Here, she learns that Harry had fabricated this story. In other words, Anne learns that her client committed perjury. And Anne doesn't affirmatively do anything. She just sits back and lets the civil case be dismissed for want of prosecution. And as soon as that happens, Wilma files her civil action against Anne, alleging malicious prosecution, abusive process, and defamation. And then we get the call of the question, and it doesn't seem as if there's anything hugely challenging about the questions presented, other than finishing on time. Now, turn the page and have a look at my outline of issues. My response to the first part of this question is very straightforward. It's just identical to what we do in all of our work in civil remedies together. I identify the theory of liability, I break it into elements, and then I discuss the elements. Each one of these headings gives me a chance to write a nice, succinct, complete analysis showing the reader where the law and the facts touch one another. It seems to me that there is no reason to do separate sections on malicious prosecution and abusive process because I think those are basically the same theory of liability. I'll discuss a distinction very briefly, but the key ideas support both theories of liability. Then I turn to defamation. This is exactly the same thing that we do in torts. I go through the elements and I suggest that the defendant is likely to prevail based on the litigation privilege. Now, turning to the professional ethics issues. Here, I do the most extreme version of using the facts for headings. I just go straight through every single thing this lawyer does, and I try to judge it accordingly. Now, take a look at the actual answer that I present. And here, I think you'll see very quickly that I am using these elements to help me cover a lot of ground quickly. This is one of my least narrative answers in professional responsibility. And the reason for that is there's so many issues presented that breaking it up into little pieces like this is something I find makes it much easier to do a genuinely complete job than writing something in a more narrative format. With regard to malicious prosecution and abusive process, I think it is evident that Anne, the attorney, filed the case in good faith. But when she learned that the action was baseless, her failure to affirmatively go out and dismiss that case gives Wilma a strong case for malicious prosecution and abusive process. Now, turning to the defamation section, here I think the defense has got a much stronger case. It is true that the plaintiff will be able to allege a per se defamatory statement, but she will not be able to establish knowing falsehood because at the time Anne filed this lawsuit, she didn't know that Harry's allegations were fabricated. And I think that Anne's absolute privilege in litigation is enough to defeat the defamation claim. So perhaps a reasonable argument can be made for the plaintiff, but I just don't see it. I say Anne wins because of the litigation privilege. Now, the more interesting part of this fact pattern, the more challenging part intellectually and also technically under time constraints, is analyzing Anne's conduct in professional ethics. And it seems to me that the most efficient way to do this is to just go chronologically through and use each thing that she does as a heading. Now, again, reasonable people can differ, and my experience is that there's a pretty wide variation in organization to many successful PR answers. So have a look and see if you don't agree that my approach does give me a chance to create a comprehensive answer. First, I examine Anne's advice about the child custody hearing. It seems to me that what she has done is reasonable. It is not improper in any fashion. So I'm not going to suggest that she be subject to discipline for giving it. Her duty of zealousness also is a valid justification to her suggesting that Harry sue for assault and battery. Also, the fact that her principal motive for filing this civil action was to improve Harry's custody position, again, I find not offensive to professional ethics. I think it is reasonable within the context of the facts as given and as we know them. Considering Anne's failure to investigate is a separate section. Now, here again, reasonable people can differ, but I just don't see any evidence of bad faith here. I don't think Anne has to go out and investigate the veracity of her own client's allegations unless there is some specific facts that might give rise to a reasonable suspicion that the client is not telling the truth. Next, we examine her filing the tort action. It seems to me reasonable again. Her reference to that tort action in the custody hearing, again, seems to me a competent and candid approach, given what we know and was aware of at the time. But when Anne learns that everything that she alleged in that action was false, she has a duty of candor that almost certainly trumps her duty of confidentiality. In California, Anne has to advise the client, Harry, to disclose his perjury, and she failed to do so. The model rules are even more strict. They would require Anne to withdraw and disclose the perjury if withdrawal is impossible. So this is the one little piece of sharp black-letter law knowledge that helps make this answer superior to what it would be otherwise. And if you're one of those many students who is actually learning about professional responsibility in California by working through a lot of these essays with me, this is the detail that you need to pick up. Next, we turn to Anne's failure to dismiss the lawsuit that she knew to be baseless, and I find this to be an omission of her professional duty of candor to the court and to her opponents. So I subjected her discipline for failing to dismiss that suit. Finally, I conclude that Anne is going to be subject to professional discipline for failing to advise Harry to report his perjury and for failing to dismiss the baseless lawsuit against Wilma for assault and battery. And that wraps up a consideration of what I think you'll agree is a legally pretty simple, but logistically pretty difficult California bar exam fact pattern.